He represents everyone from January 6th defendants to politicians, people from other countries, you name it, he's done it. He's studied under just about everybody, and about 10 years ago, he found what's called post-1933 equity, which allows a remedy for any situation that we could possibly run into. And he's a very, very smart man. I learned all I could from him, and been studying for about a year. I've put it into practice and just seen incredible results. So I'm ready to start taking on students now.
Awesome. Sounds good. We're all ready to learn too. So let's just give it one more minute. Hey, Hope, I know you're muted. You guys are going to be muted. Stay muted, because I don't want him to be interrupted. And if you have questions, just raise your hand, and he will stop and he will ask if there's any questions. And then when he is finished and ready to take on questions, Julian will also ask, for any kind of specific questions. So one more minute, guys.
Right. I'll take questions at the end. I'll ask that you all please hold your questions until I'm done with the presentation.
Beautiful. All right, so I'm going to say, go ahead, Julian, take it away.
All right. Everybody see that?
Yeah.
All right. Thank you, Michelle, for giving me the opportunity to speak to your members tonight. We're going to talk about equity as a remedy. So what is equity? Equity is the law of justice and fair dealing, which seeks a more adequate remedy than that which is available in common law or commercial, admiralty, maritime, etc. It's one of the three jurisdictions of law listed in our Constitution, and it originates from the Bible. So these are just three of the biggest kind of changes in law that happened in the last 100 years. The banking crisis of 1933, after the Great Depression, just a few days into office, Franklin Roosevelt basically passed laws which took away everybody's gold and moved us into admiralty law. Our true constitutional money, gold and silver, was taken from us, and that would have caused FDR and everybody else involved to be traitors, except that they gave us a remedy. And with equity, we can apply that remedy. Equity was further hidden from us in 1934 after the Federal Rules of Civil Procedure Act, and that's when equity, common law, and commercial law all merged into one court system. So we can still make judges put on their chancellor's hat if we compel them. And chanceries were just what courts in equity used to be called. The Supreme Court Justice, writing about the Erie versus Tompkins case, stated that everything is commercial. That means everything from your dealings with your neighbor to debts and charges and court cases. It's all commercial. Equity provides a remedy for any issue in commerce, but we have to come with clean hands. That's an important equity maxim. In order to do equity, we must come with clean hands. That means we need to stay in honor, and I'm going to talk about that later. So a joke I like to tell is that when you see a sign advertising attorney at law, if you look up at in Black's Law Dictionary, at means near. So they're just attorneys near the law. At law is a fiction. You may hear them say they operate under the color of law. Well, if you look up color in Black's Law Dictionary, that means something that has the appearance of being real but is not actually real. So as long as we stay in law, judges have to recognize our equity. And if they don't, we can put the judge in dishonor. Equity requires no particular status. I've had a lot of people ask me about status changes, filing new status with the IRS, all sorts of things. None of that is required in equity. Now, are some of these status changes going to help you in some matters? I'm sure they will. Very likely they will. But in equity, we do not need any of that. The only preparation you need is research and practice. We have rights granted to us by God and protected in the Constitution. However, we can contract our rights away. So a lot of people just state that the judges are acting unconstitutionally, it's not fair, they're breaking the law. Now, is that really true? Well, Article 1, Section 10, Clause 1 of the Constitution states that contracts are the highest law in the land. So if you contract your rights away, no judge is going to recognize them. It says it right down here. No state shall pass any law impairing the obligation of contracts. Now, that doesn't mean if you sign up for your driver's license, you're screwed. I mean, equity also has a remedy for that. So in equity, we can handle any contracts that we mistakenly or unknowingly entered into and make it as if they never existed. One of the biggest maxims in equity is that the position of the defendant is preferred over that of the plaintiff. Does it look like you're being preferred when you've tried your different processes? If not, then you might want to try something else. In order to receive equity, one must do equity. So if you're not bringing the equity, they're not going to give it to you. In fact, they're going to do everything they can to hide it from you. Why is the defendant preferred? Is because he's the only one that has the remedy. Equity is above commercial law and common law. The UCC is their law.
Julian, I need to interrupt you for a second. Are you aware? Are you aware the slides are not moving?
I've been moving them. Is it still on the first one?
No, now I see in equity it is our duty to inquire and ask questions.
Did y'all see this one?
The supremacy of contracts. No, we didn't see any of these.
Okay, I'm just going to keep it on this screen then, because I guess the full screen isn't working. So this one I just showed in the Constitution where it talks about the supremacy of contracts. No state shall pass any law impairing the obligation of contracts. But if you do happen to accidentally enter into one, like through a driver's license or a birth certificate or any of the million other ways that they have figured out to contract with us, then equity will help you to unmake those as if they never existed. And so I was just talking about how in equity, a really important maxim is that the position of the defendant is preferred because the defendant's the only one with the remedy. Let's see. So the UCC is their law. I've heard of people putting UCC on their license plates or just trying to operate through the UCC in some way or another. And, in the realm of the UCC, in commercial realm, the plaintiff wins 98% of the time when it's the government. If the government's suing you, they win 98% of the time. So you want to come out of the commercial realm and enter the higher realm of equity. It trumps their laws, and it's the only way to get a remedy that works 100% of the time for 100% of the people, as long as you know how to stand on your square, which is something I will teach you. It makes you equal to the judge. In equity, it's our duty to inquire. You need to ask questions. By asking questions, we get facts onto the record without testifying, and that's how we stay in honor. This very curious system of honor and dishonor that they have. I'll talk about that more later. But essentially, you're going to find that you're being treated very well when you go to court, when you stay in honor. And that involves not testifying, not arguing, not filing anything. A big question that we ask is, Judge, how may I settle this matter today? And that kind of tells them everything that we're there to do. Equity is about coming in peace and staying in honor. We do not argue the facts, law, jurisdiction, or venue. We do not testify. We do not file. We ask questions. We compel performance, and we use the law of notice. And the questions that we come up with are far more powerful than any argument. We compel performance to settle the matter. And think about it. Like if you show up and you're not there to argue, doesn't that take the wind out of their sails? I mean, if you're just standing there and you accept everything and you say, you know, you don't argue anything. I mean, they're not going to have any controversy to adjudicate. It just totally takes the wind out of their sails. It's pretty amazing when it's put into practice. So as I talked about before, we cannot pay for anything because they took away our gold and silver, our constitutional money. So if there's no constitutionally lawful money, then how do we settle charges? With equity, we can discharge any charge according to the remedy established in 1933. Any bill, any ticket, loan, court order, warrant, you name it. It can all be discharged in equity. The way we do this is with an acceptance. If we're given something with our name on it, we have a liability and a power. We have a liability to reply, and our reply has the power to cause discharge. The reason I put name in all caps there is because usually when we get a presentment, it's got the all caps name on it. And I like to say, don't be afraid of the name. Use the name. I believe that we are the surety for the name, but that's not something to be scared of because equity teaches you how to operate in the commercial realm while remaining private yourself. So you can use your name to your advantage and, you know, nobody's going to be able to touch you because of it. So let's look up discharge in Black's Law Dictionary. When the laws changed, the money changed. Chancery courts were eliminated because, in my opinion, equity gave the defendant too much power. So let's see what discharge says. In the process of accounting before a master in chancery, which is basically anyone who can take an oath, whether it's the garbage man or the judge, the discharge is, that's is, not, you know, if the judge wakes up on the right side of the bed that morning, it just is a statement of expenses and counterclaims brought in and filed by way of set-off by the accounting defendant, which follows the charge in order. In other words, we set off their public charges by accessing the private side of the ledger. Our acceptance is able to be exchanged at the Federal Reserve. So all of these courts have access to the Federal Reserve System. They're all running bonds on every case. They're all everything that we do in a court has been turned into an obligation in the United States, which means they're trading it all around the world. I get into that a lot in the class, but basically it means that they get all the money they need from us when we just do a proper acceptance. And I'll teach you how to do that. It's all about accounting because there's no actual money. We're just helping them balance their books. So there's a lot of instances where we can feel like our rights are in peril. And Miranda versus Arizona kind of teaches us how to deal with that. It's an equity case, and it taught us that your rights are in peril when you feel compelled to talk. So when somebody asks you a question, you got to answer their question with another question. If you make claims, you're going to have to prove your claims. So don't make any. Just ask questions, and there's nothing they can do to you. There are only two conditions when you're in law, honor and dishonor. We need to stay in honor to receive our remedy. So I was talking about before, in order to do equity, one must come with clean hands. Well, we stay in honor by showing up to help them balance their books. You start arguing laws and telling them they don't have jurisdiction and telling the judge, you know, you sent your silver dollars to Puerto Rico, so your birth certificate isn't yours anymore. And I mean, none of this stuff really helps. We're just there to settle the accounting on the matter. Because there's no actual money, there's nothing to argue about. You just help them balance their books. That's all you need to do. So how do we stay in honor and discharge any charges against us if we can't argue or testify or file anything? Well, after 1933, the laws governing all commercial matters were updated to indicate payment or acceptance. So when our name is on something, we have a liability to honor it. You're going to learn how to accept presentments, demands, charges, loans, offers, court orders, tickets, warrants, anything. And you're going to give proper notice, and you're going to set off the accounting in any matter with that acceptance. So 4 books we use: Black's Law Dictionary. We prefer the 6th edition. Excuse me. We prefer the 6th edition because it's got the most equity in it. The 5th edition will work all right. We use Burton's Legal Thesaurus, 4th or 5th edition. Levine's Manual on Commercial Law is a very important book. Lincoln Levine was a CPA in New York City during the 40s, and he figured out equity before a lot of people did, and he really condensed it all into this manual. And so I'll give everybody a copy of that. The National Edition is the one that you want. There's also the New York CPA edition, but that has like 600 less pages in it, so you want all the information you can get. And the 4th book that you're going to need is a Bible, because all of this comes from the Bible. It's all based on God's law. And the KJV has just the most instances of equity in it. So here's a few terms that you can look up in Black's and Burton's, and you're going to be able to see, if you're looking for equity in these, you're going to see it in there. There's no comprehensive definition of equity because they've done their best to hide it for about 100 years now. But in all of these definitions, you're going to see things that you can use, and it's just going to help tie everything together for you. In the class, we're going to go through a lot of different definitions. We're going to spend a lot of time in Black's and Burton's, and we're going to just glean the equity out of these definitions so you know exactly what to say when you're in court. In equity, we don't have to memorize a bunch of case law, a bunch of rules of procedure, or a bunch of regulations. That was always, something that I thought made common law so hard for people, and especially people who try to operate commercial law. I mean, good luck. There's just so much to memorize. Now, I'm not saying there's not remedies in common law. Equity is not the only game in town. But in my opinion, equity is the best remedy because it's so simple. You don't have to memorize all this stuff. You just show up in court, and if you speak with confidence before the judge and you know what to say, then he will give you your remedy. Now, sometimes they're going to test you. They're going to push back. And even if you discharge something, they're going to try to recontract with you. And so a big part of what I teach you is just how to stand on your square, how to remain firm in your equity, to stand on your knowledge. And they can try to test you all they want, but when you know what you're doing, then they're just going to have to give you your remedy. And I've seen it time and time again. It always works if you do it right. I believe that freedom is a choice, and I believe that this gives us the best way to choose freedom for ourselves and our families. So here's some maxims of equity. Equity seeks to prevent the wrong itself. So this means that equity doesn't just seek to give you financial compensation if you're wronged. It means it's going to prevent the wrong entirely. If you're being charged with a victimless crime, then equity will be your number one remedy. It will make you equal with the judge. It will help you to pay them whatever they need to be paid without you having to even open your wallet. It's really what we pay with is our signature, and that's what I teach you in the acceptance. So equity will prevent the wrong itself. It's not about paying fines and doing community service and all this stuff. Now, if you want to sign up for community service, you're more than welcome to. But he or she who seeks equity must do equity. So again, you can't just go in there arguing and testifying and filing everything and expect the judge to just come down and pat you on the back and treat you like an equal. You must do equity yourself, and that involves not arguing, just asking questions, providing notice, and understanding how accounting works, really, and not in a super deep way, just enough to help them balance their books. Equity will not suffer a wrong without a remedy. Basically, there's just a remedy for any situation. Now, that does not apply if you harmed somebody. So the duty to protect the public will outweigh any remedy that's available to you in equity. and I will not help somebody that intentionally harmed another person. So, but in every instance where somebody's coming after you for taxes, unpaid debts, any sort of victimless criminal charge, traffic tickets, especially, anything, any victimless crime, equity will not suffer a wrong to be done with you without offering you a remedy. He or she who comes into equity must come with clean hands. We already talked about this. Basically, you just to have clean hands means you're staying in honor. A commercial dishonor is a lot of methods that people provide out there on the internet will get you into commercial dishonor. It's basically just any time you testify or argue or file something, it's dishonorable. As an accountant, you must accept what's given to you and return it. So it's like if you brought a check to a bank and the teller said, I don't like the look of this check, I'm not going to cash it for you. That would be a commercial dishonor. So when we're acting as bankers, we accept everything. And that doesn't mean you accept the guilt of charges. It just means that you accept their commercial instrument that they're offering you. A criminal charge is just an offer. And so you help them settle their books on it. Equity aids the vigilant and not those who slumber on their rights. Now, that does not mean that if a case has been going on for several years and you didn't bring equity, well, you're just screwed. Equity can right any wrong as long as the case is still ongoing. And even after the case is done, like people who have gotten out of prison, they're still on parole. Well, if you're on parole, it just means that you've discharged most of the debt, but some of it still hasn't been discharged yet. And so equity can take care of that for you. But the point of this maxim is just that the sooner you act, the better. Every time I see somebody act immediately to a presentment, it gets cleared up very quickly. It's only when you wait a long time and you fall into silence that they will treat your silence as consent and act as if you are just agreeing to their charges. So the sooner you act, the better. But again, if it's been a long time, equity can still help you fully. Equity regards that as done which ought to be done and what ought to have been done. So that kind of dovetails with what I just said with the last one, is just that if you start bringing equity to a case far into the case after no matter what you've done before, if you filed a bunch of patriot theories, and given your birth certificate over to the bailiff and argued with the judge about whether or not he has jurisdiction, equity can come in and right those wrongs and bring you back into commercial honor and solve the matter for you. So it's very, very powerful. And equity will not aid a volunteer. So that goes back to the law of contracts. If you're signing up for contracts, or if the judge manages to recontract with you, then that's a problem. However, we can still solve that. It's going to be more work. So the fewer contracts that you can get yourself into, the better. And here's a few success stories just from that I've personally witnessed, or from people that I took the class with and that I studied with for the past year. A woman I studied with who was dealing with repeated threats from the IRS for tens of thousands of dollars worth of mispayments. She said, "Thank you. I just got a letter yesterday saying the case was resolved and they apologized for the error." And I have a copy of this letter myself. I can show y'all if you want. But they actually apologized to her. She said, "I've been fighting this for years and all it took was a few acceptances. This class has changed my life." A friend of mine who got pulled over for speeding, I had given him a script on what to say to an officer if he got pulled over. And he said, "That script worked. I only had to ask one question and the officer handed me back my papers and let me go. I wanted to use the whole script, but he clearly didn't want to deal with it." So I do give you scripts for just about any situation that you could find yourself in the class. And I don't just give you a script, though. I tell you what everything means in it. So one of the big things in equity is when we ask questions, we're not going to say, oh, well, don't you know by United States Code 240, violation of my rights under color of law or whatever it is. No, we don't cite case law. Our questions imply that we know the case law and imply that we know that they know. So essentially, our questions are implying a potential tort liability further on down the line if they do violate our rights. Now, when it comes to a cop on the side of the road, I mean, you only want to piss this person off so far. They have a gun on their hip. But even if you wind up having to sign a ticket, equity teaches you how to make that contract as if it never existed. It's more important for the judge. When you get before a judge, the questions that you ask want to imply that you can do more damage to them with your equity than they can do to you with anything they're doing. But we never cite case law. Our questions compel the performance that we want to see happen. Here's one that I personally took care of the whole process through. My wife had $20,000 worth of credit card debt, and it took 8 months of acceptances and inquiries, but she's completely debt free now, and her credit score was barely affected. The man I learned from has discharged millions of dollars worth of debts, and I mean, there's just, for an unsecured loan, a tax debt or unsecured debt, a tax debt or a credit card loan, it's so easy. I mean, they just melt away. A student loan, I mean, anything that is not attached to a hard asset like a car or a house is just super easy to take care of. Equity can work for mortgages and things like that too, and that's a little more advanced. And I haven't personally dealt with mortgages, but the man that I learned from has. I got a story in here about that too. Equity will work 100% of the time for anything as long as you fully know how to stand in it. So it can work for mortgages too. It's just a lot more complicated. Here's a story of a yacht owner who was arrested and ordered to attend a deposition. The attorneys asked him over 200 questions, and each time he would say, "I would love to answer that question, but the high court has ordered me to shut my mouth," referring to Miranda versus Arizona. The attorneys were screaming at him and getting red in the face, and finally they went to tell the judge, and the judge just dismissed the case. The guy appeared. That's all he had to do. An order to attend a deposition only tells us to appear. It doesn't say we have to testify against ourselves. So, I mean, for audits too, I mean, it's super simple. This is the story of the mortgager that I was referring to. This guy lost his job due to an injury, and he was unable to make his mortgage payments. He tried everything he could find, and nothing was stopping the foreclosure, only buying him time. He was in foreclosure for 2 years when he found equity. The man who taught me taught him. And after some rescissions and acceptances, 2 weeks later, he received a letter stating, "Thank you for your payoff funds," and he'll get to live in his home for the rest of his life, fully paid off. And I just want to be clear, this is not the norm with mortgages. It's usually a lot more complicated than that, but it can be that easy sometimes. Here's a recent one that I just thought was so interesting because this is another one that my teacher handled himself, but we saw some of the paperwork. So there's a young man who was in Chicago, and he was facing years in prison because apparently you're not allowed to have a gun in Chicago, even though of all the places in the country that you want to have a gun, you probably want to have one in Chicago. And he was caught with one. So after he learned equity, he showed up in court and he brought equity. And the judge yelled at him and told him to sit down and be quiet, and he'd deal with him later. And then the judge just chewed up everyone in the court because everybody else was just pleading out or hiring a public defender or whatever. So finally it got down to just this kid was left in there. And the judge left the bench, came down off the bench into the court, and put his arm around the kid, and he said, "I know what you're doing. You're trying to bring equity to my court. Just take this gun class and this will all go away." And that's the power in this. Equity makes you equal with the judge. They don't want to deal with it. Imagine never having to worry about going to the mailbox, getting a knock at the door, seeing lights in your rearview mirror, receiving a call from a debt collector or a tax agency, or being challenged on anything. That is what equity is all about. I offer an advanced course that will teach you everything you need to know about how to bring equity and stay in honor. How much is that worth? I mean, do the math. We're talking about a lifetime of tax debts every single year coming out of your wallet. Now, I'm not suggesting that people go run up a bunch of debts on their credit cards just to discharge them. That's kind of greedy. But if you have already become swamped with debt and you want to extricate yourself from this system, this is the best way to do it. And this also applies to income tax. So just do the math on that. So basically, I've given you the outline of everything. You could take that and run with it and just figure it out yourself if you want to. But I've spent a ton of time on this over the last year, and the man I learned from spent many, many years perfecting this. So if you would still like in-depth training, guidance on how to create documents, and the option for one-on-one coaching, then I'd be happy to work with you. So the class I offer will be held for 10 weeks. Sessions are once a week, about 2.5 hours long. I'm only going to take a few students. I think small classes work the best, and everybody can get the most attention that they need. And again, don't get sticker shock, because if you calculate how amazing this is and how much money it's going to save you over the course of your life, this is peanuts compared to that. So anybody interested can message me on Telegram. And that's it. I'd be happy to take questions now.
Okay, so if you want to ask a question, please raise your hand.
I saw
ahead,
Bernice.
Yeah, I unmuted her. Go ahead, Bernice. Bernice, you have to hit the unmute button.
Would that work for medical debt too?
Yes, absolutely. The hospitals are kind of in their own separate realm, but they still have access to the Fed window. So basically any institution that has access to the Federal Reserve. Now, if it's like some country hospital with like 2 doctors and they're not attached to the larger hospital system, that would not be honorable, because they don't have access to the Federal Reserve. But almost every hospital in this country at this point is part of, what is it now, like 3 or 4 larger hospital systems. They're all being consolidated. So for 99.9% of hospitals, yeah, that would absolutely be possible.
Okay, thank you.
Go ahead, Swimmy.
Thank you. Can I ask a question about an ongoing municipal court case where I have been bringing equity to the best of my ability, and maybe I think the next course of action is just appearing and speaking in equity?
Yeah, so in equity, it's very important to appear and to not let anything go by without your response. But if you have I don't want to get into like a whole in-depth review of your case, but or at least not right now. But if you have like a more specific question, I could certainly answer that right now.
Thanks. I'll be brief. It's a pretty simple case anyway, where initially I refused the summons and citations for cause, and then began to pursue equitable subrogation, appeared for the hearing, and even though I did challenge jurisdiction, I let the judge know I, respect keepers of the peace. I just wanted, proof of accounting and their authority and all that. And so then, they made me wait till the end to kind of deal with me and entered pleas for me anyway. And so I didn't really file anything onto the case. I just gave notices and maintain that I was making a special appearance to settle the matter. And now it's at the point where I've printed out the docket where they entered these pleas and accepted them and written up a consent decree. And those acceptances and the consent decree were the only things that I had actually filed onto the case up until today. Today I went in and entered just a public notice, an adverse claim and surrender in equity, of course, of the birth certificate. And so I know I may have made some mistakes, but I'm wondering if I think the best course of action is just to appear now as the beneficiary and, settle the matter.
Well, I'd say that a lot of what you're doing is equitable, and then a lot of it is other processes that may have been kind of mixed in for you. I don't know who you're learning from, but essentially, you don't need to do most of that in equity. Like you just kind of stay in your special appearance by not testifying. So a good example I could give is this friend of mine that took the class with me. She was driving into court every day for 3 hours every time she had to go to court, and the judge would ask her before the court started, "How was your drive in today?" And if she had said it was good, that would have been making a statement. That right there would have taken her out of her special appearance. So she knew to say, "Judge, does the record reflect that traffic was really bad today?" Or she just phrased it in the form of a question, basically. So anytime you make any statement or file anything, that takes you out of your special appearance. When you come out of your special appearance, you're in a general appearance, and that means that you're there for all the aspects of the case. That means that you can be made to take whatever charges they can contract with you.
So that includes filing a notice of special appearance.
Yes, you do not file anything. You send the notice in. You send the notice in. You don't pay any filing fees. Once they have it, they have it. They've been noticed. The judge is going to know what you're talking about if you refer to these things in court. Your Honor, does the record reflect that I've accepted and returned all the presentments of this court for settlement and discharge of this matter? He'll know what you're talking about. He got it. He's been noticed. You don't have to file anything. It's already on the record. But to make sure that it's on the docket, you have to ask that question in court. But as far as the judge is concerned, he's already got it. He's just kind of testing you to see if you're going to stand on it.
Thank you. What's making sense now, and what a point that you're driving home for me, and the dots are kind of being connected, is always ask questions no matter what, and that's how you stay in honor. How else?
Absolutely.
A question is so innocent.
Absolutely. And at this point, since you have made some statements and filed some things, technically these are referred to as commercial dishonors. So equity teaches you a way, it's called a repentance of sins. Again, this comes straight from the Bible. You're not repenting of anything they've accused you of. You're repenting of commercial dishonors, like testifying and filing. So that would definitely be something that I could teach you how to do.
Morgan?
Oh, thank you, ma'am. I'm in a court of equity for 4 years now, and I'm not sure how much detail to give. But it's family law, where the mother, it was addiction from pregnancy to abandonment, and then the 2 years following, where the two firms I've had so far have not performed in equity at all, and I've actually incurred more injury throughout this. And now I'm without counsel, and they're trying to recontract to the detriment of the child. And I believe I've performed equitable throughout this, and actually very loving, but with the child as the main priority through this. And I'm not sure how to approach the court or how to perform myself to ensure that the most appropriate thing happens.
So kind of as a rule, I try not to get involved in cases where children are involved, like family matters, because I don't truly know what happened, what's gone on between you and the mother. I can certainly tell you, I mean, what's been said so far, like only asking questions, not making statements, repenting of sins if you have made statements. And I could discuss that with you privately, but yeah, I try not to, I mean, unless it's like clear cut, you got a lot of evidence that you could show me that the mother is just completely in the wrong.
Oh yes, sir. I have that, and that's why I've had the two confirmed malpractices from the firms, but I haven't had anyone to support me in moving forward on that. And so I've been trying what to file, and so I didn't know if a declaration of truth and rescissions of parents' patri would be something, or but what I'm hearing is not to file, but to continue to stay in equity and to kind of move forward with clean hands and a clean heart, and just advocate through asking questions and pointing to the facts that do exist.
Yeah, I mean, if you've already gotten things on the record that indicate the attitude and the character of the mother, I mean, yes, it technically was not equitable to file those things, but if they're already on the record, you can certainly refer to them in the form of a question, not citing them specifically, but Your Honor, does the record reflect that the mother failed her last psych eval, or whatever the case may be? Again, I'm just very hesitant to get involved in matters with the child. But yeah, if you message me privately, I could probably give you some pointers. I would just need to see some of your documentation and everything.
Oh yes, sir. I appreciate it.
JW, you want to ask your question?
Oh yeah, I wrote it in the chat there. I actually have to run, so I wrote it because I'm not able to talk much right now. Thank you.
Okay.
All right, let's see. Is this the chat in the group? Okay, I see. Will students be provided an invoice for the cost of the class that the debtor, offerer, or mentor who knows how to receive a tender acceptance will cover the tuition? The W-9 to this. I guess he's asking if I'll be able to take, if they'll be able to pay me in the form of an acceptance. I do not have access to the Federal Reserve, so I'm afraid you would have to actually pay me in Federal Reserve notes or crypto. Yeah, I don't mess with the W-9 process. I don't mess with 1040 sandwiches or whatever the hot new thing is. So basically, like, if say you borrow $10 from your neighbor, you can't just write an acceptance on that and give your neighbor a notice of acceptance. Say, all right, yeah, I paid the debt to you, buddy. I'll see you next Tuesday. Your neighbor can't go to the Federal Reserve and exchange that acceptance for FRNs. So that would be very dishonorable. This only works with institutions that have access to the Federal Reserve, and the IRS, Citigroup, Discover, whatever credit card company you're dealing with, student loans, mortgages, any of that kind of stuff.
Jeannie, did you have a question? You had your hand raised earlier.
Yeah, how much is it to take the courses that you offer?
As a donation of $1,888.
Okay. All right. Thank you.
Yes, ma'am.
Are you doing it in any kind of payment plan or anything like that?
Yes, you can do half up front and then the other half halfway through the course, and you remaining in the course would be dependent on that.
John, you had your hand raised?
Yeah, I was you gave a good example earlier of someone in court said, "I would love to answer that question, but what was the last part? Restricted by law or something?"
Are you referring to the family court or?
Just before you gave an example, it was about 10 minutes ago, but like as equity would
Oh,
be
the deposition guy, the yacht
the
owner. Yeah,
deposition.
they called him in for a deposition. He had been arrested previously. The judge ordered him to attend a deposition, and basically, an order to attend a deposition just says you have to appear. It doesn't say that you have to testify against yourself. So, for example, if they ask you, do you swear to tell the truth, the whole truth, and nothing but the truth? No. What are they going to do? I mean, I've heard of cases where somebody said no, and the whole court just like was dumbfounded, and the court clerk was like, I don't even know what to do right now. Nobody's ever said no.
Can get you for
So,
contempt.
well, not in a deposition they can't. In court, we have ways of handling contempt, but you can. Essentially, in a deposition, what this guy did was that he would answer the question saying, "I would love to answer that question, but the high court has ordered me to shut my mouth," and that's just referring to Miranda versus Arizona. And they probably asked him the question over 200 times, and they weren't ever able to get anything else out of him, so the judge dismissed the case.
The high court has told me to shut my mouth. Is that what you said? That's what I was.
I would love to answer that question, but the high court has ordered me to shut my mouth. Yes.
Ordered me. Got it. Thanks.
Hope, you have a question?
Yeah, I was referring to the God's law and an equity. And God's law is maximum law. And I mean, even in a family court, it's the heir, meaning the heir that alone would make the law. So I guess where I'm a little confused on the equity, it's not necessarily one party or the other, and I'm only going on from my own experience because I'm in the middle of this right now. As a grandmother and having grandchildren that are the heirs of me, and the parents are no longer in the picture at this time. So going back to going into equity with clean hands, that's very important. And to remember, I this is my impression of equity. Equity doesn't necessarily mean how you behave or how the other person behaves. I think the right dictates the law. So where I'm a little confused is when you go into that jurisdiction, it seems more of a pleading than a law. And if God's law is the maximum law, how could that possibly make it equal with the judge? Any opinion on that? I yield.
Well, so you don't argue jurisdiction. You're equal with the judge because you're there to help the judge settle the accounting on the matter. I guess an example from the Bible I could give you is Jesus quoted one of the Psalms when he said, "Have I not said that ye are gods?" And that's with a little g. And that's referring to the book of Judges when men were given so much power over other men that God kind of tongue-in-cheek almost refers to them as little g gods. Now, a lot of people like to take that verse and run with it and do all sorts of read things into it that aren't there. But I interpret that to mean how much power God has allowed a judge to take up. And I believe that they will be judged more harshly themselves for how they wield that power. But for the time being, they're the ones that can give you the remedy. So they respect equity. They know what equity is, and they are more than willing to give you your equitable remedy if you know how to stand in it. Does that answer your question? Or?
Well, I think where my confusion is standing in your equity and you have clean hands and requesting from a judge isn't the only avenue. You could still present yourself in law, in God's law, which the Word of God is law. So the Word of God, I'm not just talking God's law, I'm talking the Word of God is law. So, for example, the young man that was just talking about his own offspring, and he's in good faith, he feels he's in good faith and all other stuff. The offspring is the heir. So if I'm standing in that, the offspring is the heir.
Well, the thing is that
equity,
you...
just let me finish on that for a second. Just the equity in that isn't going to request from a judge that has no heir other than just equity in this. It wouldn't be equal. I don't think it couldn't possibly be equal is where my confusion is. I just don't think that it could ever be equal in that position.
I think I get where you're coming from. I mean, just strictly morally speaking, you know, they're your children or your grandchildren. It's your family. I'm not really sure about what all's going on with your situation, but I mean, morally speaking, you know, you could always pick a bone with the judge and say, you know, he doesn't have the right to stick his nose in your family. But the only reason that we wind up in front of a judge in the first place is that somebody tried to contract with us and we either didn't know how to deal with it or they escalated the situation, and we have to deal with it again. So, I mean, if you know how to stand on your square, the judge is going to recognize what you're doing, and he's going to give you your remedy. I mean, the part about making you equal with the judge is just as far as the court is concerned. It's not like the judge is your equal under. I mean, we're all brothers and sisters and children of God. So I guess I'm not quite sure what the hang up is on the equality part, but I don't know. Hopefully
because when you have an offspring, and this is again going back to the law of God, God's law, the law of God, your heirs, your offspring, are deemed as one. Okay, or one body. So we're one body in our heirs. Okay, through generations or whatever. I'm trying to kind of break down the words a little bit. So even that alone, by reason of unity, okay, that alone is a maximum equity, and there's no way possible a judge could have an equal standing. We can't have an equal standing with that, with a judge. So you can, I'm thinking you can go in and just stand on that alone and request a settlement and a discharge just on that alone.
I mean, if you would like to try that, then I mean, you're more than welcome to. It's not. I don't think it sounds like the process that I've learned, but you know, if you believe that you have discovered something that speaks to a deeper level of God's law, then you're more than welcome to try that.
I just wanted to throw that out there because I've been doing a lot of research on the heirs since the murder of my daughter, and the biological father, who's my son-in-law, committed the murder, and he still has his parental rights, but I'm going to go in there on the grounds, even though he has full rights to his offspring, and I had to accept that. It's a real tough one because I don't think he has clean hands, but he didn't hurt the children. So he still has his parental rights. Now it's up to me to go in there and say, you know, I could say, well, an eye for an eye, you took my child, right? But that's not how we go into equity. We go in with a and trust me, 6 months ago I wasn't talking like this at all. But I've come to settle with the idea of what God's law is, and His word is, well, God's word is law. So the right equals to the law, always goes to the law. So I'm thinking, okay, in equity, I have to accept that He's the Father. He has parental rights; they have not been revoked, and He has that. He still has that. So I'm going in and saying, settle and discharge and revoke his rights, and going
Yeah,
in
well,
with clean hands. So it happens. It exists out here. So it's not about his actions, what he did. It has to do with the right, which is his heir. That's his offspring, his direct
right.
offspring. So
I
yeah,
understand.
that's where I am right now with it.
I mean, first of all, I just want to say that is where you are with all this is amazing. That you don't have a
Thanks.
heart full of vengeance. I mean, that's just incredible and really speaks to your relationship with our Creator.
Thank you. Didn't get there overnight. I've had some support. Michelle's one of them, and some other people that are on here that have really helped me process through this, because I was gun swinging there for a while, so it took some time, but this is where I am today. So, but thank you.
Yeah. Unfortunately, equity really is to help you if you're the defendant. If you're trying to go in and, it helps you if you need a remedy. It doesn't help you kind of take rights away from somebody else. I would, given what you've told me, I would love to see his rights to the children taken away and those rights given to you. But equity is more for if somebody's coming after you. It doesn't help if you're going after somebody else.
Yeah, I guess I just wanted to throw it out there that I have learned through this process that the law favors a man's inheritance, and it also an heir, or an offspring, is a term of law. So it's a son of one of nature. So I just want to throw that out there for people who are trying to obtain good relations with their children. If you can handle it outside the court, please do. But don't bring the court into your private, because they will definitely try to destroy your family. But I just wanted to throw that out there. But I appreciate it, and I have a lot of respect for this course that you're pushing out. So I'll continue to listen. Thank you.
Eric?
Oh, hey, Daniel. So I don't really have much. Is it safe to say you've been doing this for a while, right? Like, was I just hearing you in videos or audios from 2011?
Well, that's the guy I learned from has been doing it for that long. I've just been pouring myself into this for the last year. But before that, I'd studied a lot of other things, just trying to find remedies, and nothing worked. When I found equity, everything changed. And for the last year, I've just been pouring myself into this, and I've seen a lot of success so far, yes. And the guy I learned from has been doing it for a very long time. He defends January 6th victims, defendants that were rounded up at the Capitol and tricked into going inside. So he's very, very knowledgeable.
I think your voice sounds familiar, so I was just going to throw that out there. But God bless you. Thank you for everything you're doing. I will. So I didn't hear much about any of your course because I jumped in late. What you're offering a course? Is that what I heard?
Yeah, that's correct. It'll run for about 10 weeks. And you can message me privately for more details. I think also this call was recorded. I'm pretty sure Michelle recorded it, so you can rewatch it.
All right, cool. I'll do that. Thanks, man. I appreciate it.
Anytime.
Robert?
Hey, how's it going? You pretty much answered my question just a while ago in regards to bringing equity as a defendant. but as a plaintiff, perhaps, or a claimant, um, isn't equitable relief somewhat similar, or no?
There is such a thing as a bill in equity, and there's also equitable redemption, which it's still a defendant, but you're kind of seeking to get something. So um, there are bills in equity. I haven't really dived into that much, and I don't really know anybody who has. But that would be an interesting thing to look into, certainly.
Oh, most definitely, because I've been paying attention a little bit to Derek Gonzalez, I believe it is, DG, and how to bring a claim, whatnot. So I was wondering if these two tie together. That's all. But I appreciate you.
They probably do not. Equity is very important to not mix any processes with equity. It's very important to maintain your special appearance. Most other processes require you to file a claim, make a claim, testify, argue, any number of things that will cancel your special appearance immediately.
That's about what I figured. It's more on the defense side then, right? Correct?
Absolutely. The position of the defendant is actually the preferred position in equity, even after judgment.
Gotcha. Awesome. Well understood, man. Appreciate you. Thank you.
JT?
How you doing, sir? I got a regular divorce back in November, and we go through the process, and you pay the money, and then you got to wait. In North Carolina, you got to wait a year to get divorced. So I just wanted to know if the constitutional law is going to put this situation into a way that if you were never by the old law, if you were never married, do you have to get divorced, or how does that work? Because I'm wanting to get married before the process time of June 24th next year, 2024. Me and my friend that's wanting to be getting married together, but I just need to know if I can do this before.
Okay, that's a great question. So one of the things that people I know like to ask themselves is, do I want to make the state the third party to my marriage? Do I want to have a menage a trois with the state? There is no reason, unless you want a tax benefit, which if you know equity, that means nothing to you, to allow the state to tell you that you need to ask them for a license to marry your wife. You don't need to do that. You can make a covenant between your wife and God, and also you can rescission any marriage that you got into with the state. So for your previous marriage, I mean, that's just a contract that you entered in that you made the state a party to. You can rescission that contract and make it as if it never existed. Okay. That's a very powerful thing. I mean, even if your previous wife were to take you to court, Your Honor, does the record reflect that there never was a marriage? Rescission necessitates repudiation. That means that when you rescission something, it makes it as if it never existed, and you have to act like it never existed.
Do I have to have a constitutional lawyer to rescission it before I do it? Because I have a constitutional lawyer I'm talking to.
No. You never need a lawyer in equity. You must represent yourself. In fact, you just present yourself. You don't want anybody to represent you. There is commercial law rescission, and that's where you have to ask the court to rescission something for you. But that's not what we do. We do equitable rescission. And the Supreme Court has outlined that there are 3 reasons that we may rescission a document and make it as if it never existed. That's for impossibility, like you sign a contract to drive somebody to the moon in your car. That's impossible. So you would be able to rescind a contract for that. Fraud, which you never want to argue fraud in equity because you have to prove it. And the third reason is a mistake. And nobody can tell you that you didn't make a mistake signing something, presenting something, handing something over. So you can rescission for the cause of a mistake, and that is fully in your right to do. It's backed by the Supreme Court. It's an equitable remedy. and it makes the contract as if it never happened. You just have
Wow.
to.
How do I get that started?
You just have to know how to make the notice of rescission and how to stand on your square if you ever have to if somebody ever wants to challenge you on it in court. You got to take the class, basically.
Huh. So, for me to have to rescission it, like, anytime, like I can do that anytime before December 3rd. She has 10 days technically, between November 31st and 10 days after, because that's what I'm saying. That's the old law. But the constitutional law, like you're saying now, is like you can rescission and you can say it was a mistake. And how, I mean,
Yeah, you can do that at any time. And equity works at any point after the contract has been signed. If it's been 10 years, 20 years, 30 years, it acts as if it never happened. That's what a rescission is. It makes it as if it never were.
okay. Well, what's coming up is the revaluation of foreign currency, and then you'll have a little bit of money to do this kind of thing. Because how much is your course?
It is a donation of $1,888.
Okay. Well, I can do that afterwards, and it'll still be something I can be able to pull off. So I just need to get, and could you put a link at the bottom here so I can learn how to rescission, and I'll be able to pay the money after I get the revalue of my currency coming up. I hope in the next couple of days. So
Yeah, great. Just message me. I have my handle up here at Vitiate0. It should be on the screen right now. And you can just right-click on my name and click send message, and we can work out the details in a private message.
all right, I'm sorry, I didn't see that. Can you show it to me again? Can you put it on the bottom? Oh, you can't. Yeah, send message at this wall here for me.
Yeah, if you right-click where it says Julian, it should show that I'm speaking right now, and I don't know if you can see the participants in the meeting.
Yes, I see it right here. And then send you a message, right?
Yeah, just right-click on that. It should be a picture of a overgrown church with a bunch of plants in it.
I got you. I'm gonna say this is JT. I just sent
there
it to
it is.
you.
I just got it. And for everybody else that's sending me messages right now, I'll get to you just as soon as we're done here.
That's great, Julian. I like to be able to learn how to do that and get rescission, because I did not want to do this marriage after the fact. But sometimes you just have to learn, live and learn. So I really have a real good woman, I believe, that wants to get married this time. But then you have to get married by a justice of peace, right? For it to be legal, right?
Well, depends on what you like. If you're looking for a benefit from the state,
don't sign it. Don't sign a marriage license.
Exactly. That's what I'm getting at. Is that if you sign a marriage license, you're inviting the state into your marriage, and it can cause problems for you further on down the line. Now,
your offspring.
The only benefit that I could think of is, God forbid if somebody needed the right to visit you in the hospital or something, and God forbid anything like that happened. But I've never heard of a hospital asking for proof that somebody's your wife. So,
or if you want to bring her from the country, different country.
Yeah, that too. That would probably be a lot more complicated.
Well,
but you can also, if you get yourself a family Bible and you record the marriage in there, that's a legal document, and that's just between you, her, and God. So
she's the ordained minister.
Well, there you go. You mean she doesn't even have to be, but that could only help. The marriage
she's an ordained minister.
Just consummate the marriage. That's all you got to do. Just consummate the marriage.
Exactly. You just take her hands and make your vows before the Lord, and that will be a marriage.
Wow. Okay. Well, I'm glad this is recorded so I can tell her what I've been listening to.
Yeah, and you can go to Vegas real quick. You can do shotgun wedding in Vegas if you want.
Oh, they don't do the marriage certificate thing? You just get married in Vegas with like that the same way?
There you go.
No. He's just joking.
Okay. Oh man.
I'm just messing.
Okay. Well, rescinding my marriage to the other one, and then this one, all I have to do is get a family Bible and then say my marriage vows in front. Do I need to record them in front of my Bible?
No. I mean, it definitely sounds like the first marriage was a mistake, so you're well within your rights to rescission that. And
Okay.
for this other young lady that you'd like to marry, you just say your vows.
She's a minister. She'll figure it
Say
out.
your vows
Yeah.
before God.
Okay.
You know,
All right.
I'm
Well.
sorry to interrupt you guys, but real quick, let me tell you something. In if you go through the so-called dissolution in through the courts, there's no such thing as divorce even. So if you look at your if you even look at your marriage license, you won't see a place for divorce. There's no place. It says dissolution because they don't want you to break your contract. That's what they want you to stay in that contract. That's why that contract is so strong. So you revoke your signature. Revoke the contract. You rescind your signature is very powerful. But if you don't have children or any kids, then you're pretty cool.
So dissolution is the same thing as rescission, and I could just
No.
go.
No.
Dissolution is like when you get divorced. Like there's no such thing as divorce. There's no word for divorce in the legal in that if you go to you can do separation, you can do dissolution, but there's no such thing as like divorce. That's just a made up thing.
So let me just say the only thing that you need to do with the previous marriage is do an equitable rescission, and if you are ever challenged on it, you just have to know how to stand on your square with that. So if anybody ever takes you to court and tries to invoke your previous marriage, you just say, "Your Honor, does the record reflect that there is no marriage contract? Your Honor, does the record reflect that there was no marriage?" It doesn't. You don't say,
Good point.
"Your Honor, did you not receive my rescission? Did you not see the rescission I did on that?" Because you just acknowledged that there was something to rescission. Rescission requires repudiation. That means you act as if it never happened.
That's a very good point. Very good point.
The only thing I would worry about is on the 10 days if she doesn't get a lawyer in the old one, then I'll be like, it doesn't matter because I have an equitable decision with rescission, right? And I just tell the other lawyer, right? Is that what I'd tell her?
So you would copy the other lawyer on your notice of rescission. He would be one of the CCs that you would send a copy of that notice to if she already has a lawyer.
She's already lawyered up?
She don't. She don't have a lawyer, and I know she won't get one. She told me, if you're happy after a year and you want to get a divorce, I'm okay with that. So then after the 10 days, it's going to be good anyway. I don't have to worry. But I just want to make sure that I could do something to make sure that I could tell my new partner, I don't have to worry about this woman because she's not going to do anything anyway. But I just don't want to know for sure that this is going to happen until this thing right here with the constitutional law just come up in my head a couple months ago. And I just wanted to talk to somebody, and that's why I got on this line. So
well,
I'm seeing that you understand what I'm talking about.
Yeah, just private message me and we'll work it out. Rescission's definitely a very powerful tool that we can use for marriage contracts.
All right, I will, man. I've just sent you some names and maybe rescission, equitable decision, and this is my name just as JT. So I had to remember them, so I put them in this message, okay?
All right, that's all good. Thank you.
All right, thank you, everybody. I appreciate you giving me time.
Johnny, did you have a question?
I actually did, yeah. How you doing?
Good. How you doing, Johnny?
You guys in a long time, yeah. So I was wondering, talking about the rescission. So from what I understand, is each state has their own contract rules, more or less, in terms of rescission. I know there's a 3-day automatic I guess rescission. You just kind of like a grace period. But I believe that if anybody heard this, but if you have a contract that does not have rescission rules or rescission like bylaws or like a waiver, then I think if I'm not mistaken, you can have 3 years to rescind that contract or revoke your signature. You were saying something about fraud that it could be for as long as as long as you want, but of course you have to prove that. Does anybody have any ideas about that? Or?
So, as to your first point, there are a lot of laws that courts and states and contracts will try to put on a time limit for commercial rescission. And for commercial rescission, you can't even do that yourself. You have to ask the court to do it for you. So that's why we do not operate in the commercial realm. We operate in equity, and in the equitable jurisdiction, we are allowed to rescission our own documents. There is no time limit. It could be, and I teach you how to do that. Basically, it's 30 years down the line, you want to rescission something, it's fine. It acts as if it never existed, even though it's been 30 years. And then, as for the second thing about, what was that?
Oh, I'm sorry. You said that, but in the court, it would be different. What does that mean in the court?
Well, so there's rescission in commercial law and there's rescission in equity law. So in commercial law, when you don't know what you're doing and you just hire an attorney to do everything for you, and you just sit there and be quiet and then be represented by some fictional attorney who doesn't know what he's doing, you have to ask the court, may I please rescission this? But in equity, we just rescission our own documents. The Supreme Court has said that we have 3 reasons that we can do that: for impossibility, for fraud, or for a mistake. And mistake is very easy to use. I mean, nobody can tell you that you didn't make a mistake on something. So it's pretty simple.
Right. Sorry. So when you say that you need the court's permission, are you saying that signature or that contract has to be signed in front of the judge in order for you to?
No.
In order for it to be that you can rescind it from the judge, or no?
That was just an example I was giving of something that happens in the commercial jurisdiction for commercial admiralty, maritime, international law. Yes. But we don't operate in that, so you don't have to worry about that. It's just, if you learn equity, I can teach you how to write a notice of rescission for cause, the cause being that you made a mistake. And you don't have to ask the court to do that. You file that notice, and you got to stand you got to know how to stand on your square with it.
Right. I appreciate that. I was just trying to figure out what happens if you have a stipulation in the public court. That's what I was trying to figure out.
Oh, stipulation always gets rescission. If you had an attorney represent you and he entered into a stipulation on your behalf, you need to rescission that. Absolutely.
Do you need permission from the court?
No. You just use equitable rescission. If you already have an attorney, you're going to want to attorn that attorney, and there's another form that I teach another notice that I teach you how to write. And when we attorn an attorney, basically just tells the attorney what they are and are not allowed to do. You tell them, you may not argue on my behalf, you may not file anything. I mean, you don't even really want an attorney, but if you already have one, it's more honorable to not fire them. You can fire them if they start, standing up and testifying and saying all sorts of stuff you told them not to say. And there are a couple occasions where an attorney might be useful. There's certain court record systems that only bar members can access, and they can help us with that sometimes. But for the most part, you don't even want an attorney. But I can teach you how to attorn the attorney and rescission any stipulations that you were entered into.
All right. Thank you so much.
John, did you have another question?
Johnny? No, I'm okay. Thank you.
It's just to push,
Hey, Sean,
because
sorry.
when the speaker is speaking with the video, if you hold the name down, if you tap it, eventually gets there to Julian's Telegram channel, but then it says, because we don't have mutual contacts or something. So I'm still working on the problem.
Yeah, so I thought my screen was sharing, but I guess there is a way to cycle through, like he was saying, and then if you right-click on my name, then it'll allow you to send a message. If
You
you
actually
look
have to hold it down. A click doesn't work. You have to hold it. That's what I found on my phone, but I'm not on Apple. I'm on Android.
okay, I'm on a desktop, so that's probably why I can right click. But yeah, I mean, there's going to be some way that you'll be able to look at the list of participants and get inside my drop down menu somehow and send me a message. But thank you.
Do you have another Telegram channel called V80?
That's my handle, so I don't think it's on a channel necessarily. It's like that's just how you private message.
Vitiate. So
Yeah, at vitiate and then the number 0. VITIATE and then the number 0.
thank you.
I have another quick question or two.
I was just gonna call on you. Go ahead, Swimmy.
Thank you so much. So I really like what I'm hearing, and I do want to take the class, so I don't want to get too in depth. But first question is, what happens if you ask questions? You're asking questions to say like, Your Honor, does the record reflect that there's no controversy on the case, something like that, and the judge starts answering no, something like that.
So there are sometimes the judge is going to try and test you and recontract with you. It depends on the situation. Like if you say, Your Honor, does the record reflect that I've accepted and returned all the presentments of this court for discharge and settlement of this matter? And he says, no, I don't know what you're talking about. We can say, Judge, I accept your dishonor. And at that point, we stop calling them Your Honor. We just call them Judge. And when a judge is in commercial dishonor, he's no longer allowed to adjudicate the court. So this is an example of a question that implies potential tort liability, and that can compel the performance of the judge to give you your remedy.
That's a beautiful answer. Thank you. I'm so glad I asked, because I also had that question. When do I call them a judge? When do I call them Your Honor? My other one is really, is there ever a time where it's too, well, you kind of said no, to step in and with equity, like say you sent a notice and that you're making claims and you're making claims of harm and injury by way of trespass, it seems equitable to just rescind and take that back, eh?
Yeah, if you've made commercial dishonors, then I teach you how to give a notice of repentance of sins, and that will put you back into honor. And from that point forward, you need to only be asking questions and not testifying and all that. But you can also rescission any documents that you might have filed, anything that would have created a contract or anything that would have put you into commercial dishonor. So equity has a remedy for everything.
So much. It's awesome.
Eric, did you have another question?
No, I accidentally hit it and I couldn't figure out how to undo it. So no, I'm good. Thank you.
Okay.
It's good to hear from you, Johnny D. I haven't heard you in a while out here on the chat.
I was stuck. I wasn't able to say thank you. I appreciate that, Eric. I was going to ask another question because Julian mentioned if your judge is in dishonor, that he's not allowed to. I think you said adjudicate, if I'm not mistaken. That's very interesting that you said that, because doing the administrative process, doing the private admin, and getting these the attorneys or the opposition, and even the judge stuck into their default system, and kind of getting them on the private side. I never heard that a judge would he wouldn't or he or she wouldn't be able to adjudicate after if he's in dishonor. Could you explain a little bit of that and how we can maybe perhaps use that if we are in a situation where they are according to you in dishonor, and if you don't mind elaborating a little bit of that.
Absolutely. So you must be in commercial honor in order to preside over anything. When when the case is transferred to the judge, technically it's assigned to the judge. And what assignment does is it passes title. Since they've kind of turned all these court cases into financial instruments that are traded on the international market, it's just banking rules. I'm not exactly sure where it says it in the UCC, but you're not allowed to kind of handle a title if you've fallen into dishonor. And there's multiple ways that we have of getting that dishonor on the record. For the one thing, you start calling them judge and you say, I accept your dishonor, but you can also issue a notice of dishonor. You can follow that up with a certificate of dishonor, which actually gets recorded with the Secretary of State of your state. And it'll show up on a UCC 11 search. If somebody ever runs a search on the judge, they'll be able to see that they were put into dishonor, and it can even affect their credit score. So it's a boot to the head, basically, if they're trying to fight you left and right. It's one way that we can really compel performance from them.
Oh, that's awesome. That's awesome. Sorry to I want to elaborate on that. So, just to clarify, so Secretary of State, we're going to show the dishonor in the Secretary of State. But you mentioned something about the bond and they traded. Are you able to actually locate that actual bond, and are we sure that they've actually established that bond, or are we thinking that that bond is out there for us for the option to purchase, or has it already been created? And do you have any way we can prove that or anything? Sorry.
So that's a good question. So one of our equitable questions deals with the existence of these bonds, and we just know from experience that this compels performance. Now, there are people that claim to be able to find what's called the QSIP number for your case. QSIP is a Securities and Exchange Commission standard. It stands for Community on Uniform Investments and Securities Protocols. And when something has a QSIP number, that means it's being traded on the open market. So one of our questions is, Your Honor, why does case number blah, blah, blah have a QSIP number associated with it? Doesn't QSIP stand for Community on Uniform Investment and Securities Protocols? And this is another boot to the head that implies a potential tort liability, because that's highly illegal. You're not supposed to be doing that. These people's lives you're dealing with here. They're not, just your toys to be trading. Anyway, I'll give you a list of questions that you'll be able to ask in court that are just verbal boots to the head that will compel performance. And I'll also teach you what each one means.
Thank you.
Julian, there's a question in the chat from Julie. How does illustrate plaintiff unclean hands without making any statements? Also, what happens if by no responding, a court awards a default judgment without giving you the chance to receive equity?
Okay, so first of all, the plaintiff is likely going to be a bar member, which means he's not even allowed to bring equity in the first place. We've seen in a lot of cases that when we start bringing equity, and then the plaintiff gets all bent out of shape about it and starts, standing up and say, "Oh, I don't know what he's doing. This is nonsense. I've never heard anybody do this before." The judge will actually tell him to sit down and shut up, because they're not even allowed to bring equity. They'll lose their bar membership if they even try. Let's see. What was the second part of that question?
Also, what happens if by no responding, a court awards a default judgment without giving you the chance to receive equity?
Okay. Yeah, you can just accept and return the default judgment. It's if you've already gone through a whole case and everything, there's going to be more things that you want to accept and return, and possibly some things that you want to rescission. But a default judgment is an offer. It's a financial instrument, And so when we return it, especially if the judge has signed it, our returning of it makes him liable to settle and discharge the matter and settle the accounting on the matter. And I show you how to do that.
Swimmy, you had another question?
Yes, thank you. Aren't judges bar members themselves, or are there certain judges who can give equity and certain who can't?
Any judge can put on their chancellor's hat. Chancellor is just the judge over a court of chancery. They were all merged into the same courts now, so the judge wears multiple hats. But yeah, I guess that's a good point. I think many of them are bar members, if not all of them. I'm not really sure, but it doesn't seem to matter. Once they put on the chancellor's hat, so to speak, they're able to give us our remedy.
Wow, so that even applies to like municipal court judges or administrators, huh?
Sorry, what was that?
Even like a municipal judge, that would apply there, it sounds like.
Yeah, any judge. Magistrates are kind of like a lower level judge, and they often don't understand equity. But another principle of equity is that if the judge doesn't understand it, they have to transfer your case to a judge who does understand it. And they know that.
Nice. Thanks so much.
Morgan?
Thanks, ma'am. I was looking over some decrees that have some of the contracts that are signed by all parties involved, and it was never communicated to me, and I didn't understand, but I just noticed that there were stipulations placed in there, and I'm wondering how I can rescind that. Can I do it now being on my own in open court, do a rescission to the judge, as well as asking if she's an equitable judge, or is that something I have to follow up with paperwork?
Well, all judges are equitable judges if we compel them to be. They can all act as a chancellor, and especially in a family court. I mean, a family court is already a court of equity to begin with. So as far as the stipulations, you just need to get a copy of those, and you would rescission those with a notice, and then you would just stand on your square with it in court.
And would that notice be in open court, or would it be filing with the clerk?
You would not file it. You would send it into the clerk. And if they send it back to you, as they sometimes do, you would send it again. And usually the second time they won't send it back. And then you know that they've been noticed. You would copy the judge on it. You would copy the other person's attorney. You'd copy the clerk of court. And I'd teach you how to do all that in the class.
Okay, and so really it's just a notice of rescission sent to the clerk and opposing counsel, and then the judge becomes aware of it from the clerk of the court.
Yeah, you would send it to the judge through the clerk of the court. Yeah, and there's just a specific way to word it and all that, and then how to stand on your square with it in court is very important because they're probably going to challenge you on it. So. I wouldn't just take any notice of rescission you find online. It's not just a template that you use. Like, you have to understand what everything in there means, and you need to include certain things. And then you need to be able to confidently defend that with questions in a court. So it's a little more involved than just using a template.
Okay, where I find myself now is there's declarations made in support or statements made by the judge, which they've now leapfrogged and fast-tracked to an evidentiary hearing, which I'm led to believe is a kind of a final decision, and that will be showing up on my docket any day for the court date. So I'm trying to get as much in order before I have to go kind of be on my own and stand on my own in court. So I'm trying to figure out what necessary things I need to do. But if that's not a smart move, then I shouldn't do
How long do you have before your next court appearance?
They haven't posted it on the Supreme Court network for my state yet, but I assume they gave me a window since my counsel withdrew. There was a 30-day window, and I assume that there will be a motion once that ends, which I believe will be within the next week, and then it will probably be 2 weeks after that. So within a month time frame.
Okay. It's gonna take more time to learn if you did the whole class. It's a 10-week class, but I could handle it with you personally. Just do some one-on-one coaching, and we could get through it a lot quicker. And I could certainly have you ready in a month's time. I mean, it depends on your ability to grasp everything and to stand on your square. I mean, it's only 50 to 80% of your remedy comes from the paperwork. I mean, 20 to 50% of it is going to be you standing in court, asking the right questions, using a tone in your voice that just speaks confidence and makes the judge realize that you're not just reading from a script, that you really know what you're talking about.
Okay, perfect. I appreciate that. Thank you.
Absolutely.
Jeannie?
And sorry, real quick, just to all the people that are messaging me right now, I'll get to all your messages just as soon as this call's over.
Jeannie Ball? Yeah. Oh, there you are. Okay.
Yeah. If we take the course and then we have questions afterwards or we need help, will you help us with it?
Yes, absolutely. If you don't give up on me, I won't give up on you. And I'm here to answer all of your questions. Once you pay for the class, I'm your teacher until I take my last breath.
Okay, thank you.
Does anybody else have any other questions? Just raise your hand if you have a question. JT? JT, do you have a question? You had your hand raised again.
Yes, I'm sorry. I said when you said it was rescission of a marriage contract, that part of the class, is that a separate part? Do I have to take all these parts, or just is that a particular part that I have to pay for?
No, it's all in one. If you just want to do that, then and you don't want to take the rest of the material, then you can just
Yeah.
message me and I'll work it out with you one-on-one.
Okay, yeah, because that's all I wanted. Because I mean, the other stuff, I don't have any problems with none of that yet. Okay, because I'm gonna have a trust, and you don't understand about the trust things, do you? Maybe I could ask you about that too.
Well,
Like
there
a
is
common law trust. I've got a
yeah,
regular trust.
there's private equity trusts, and that is kind of another realm of knowledge that I've been stepping into recently.
Yeah.
But that, right now what I'm trying to help people with is just so many people are dealing with situations where the IRS is coming after them, where they've been charged with some victimless crime, where, they've just been run through the mill of the court system. And right now I'm just really focused on helping people deal with those issues and come out of Babylon.
Right, I understand. I mean, I didn't never take out no federal taxes for 3 years, and they haven't come after me because the IRS is dead anyway. But the whole point is I'm not worried about that too much because that's not a whole lot of money. But as far as they going with the trust, I signed the trust ahead of time before I go into a redemption center to refinance, revalue my foreign currency, and that's all that's for. and then they get us to sign another trust for common law. Okay. So I have another person that's got common law trust for 3,000. I didn't know if you knew anything about that or not, but I'll just ask you later about it. But mainly just about the marriage part. I will message you and we'll get that straight. I appreciate it, sir.
Done.
Lex, did you have any questions? James, did you have any questions?
Yeah, just one. It's regarding a any post decree contract, in a divorce or whatever, where you've got to pay for, they have these ridiculous ones in Illinois where you got to pay, kids tuition. I mean, all these ridiculous things that the laws kind of crafted and enslaved people with. Those are all, that would be subject to rescission as well, right? You just go all the way back to the beginning where there was there was a mistake, and then basically it's void ab initio, right? Is that correct?
What you said about going all the way back to the beginning is exactly the idea. Yeah, you rescission all the contracts that you entered into throughout the whole process, going all the way back to that marriage license, and that's definitely something I could teach you how to do.
Right, and that beside credit card debt, also this is also any kind of victimless crime, right? So again, you said that traffic or any of the well, I guess you said it right, victimless crime. So anything not to do with harm to a man or another woman. The equity is it seems like it's the most direct. I mean, it cuts it to the chase right out of the gate. Dealing in equity on a defensive standpoint, it's almost it's like sitting in a castle, almost.
Yeah, that's a great analogy. Pretty much, because when you cut to the chase, everything's commercial. I mean, they're just, it's all about money, and since there's no real money, they're just balancing their books for the Federal Reserve. So, I mean, you just help them do that, basically. When you go in there and you start arguing and testifying and filing things, you're getting away from the heart of the matter and going off into this kind of playground that they've set up for people to entrap themselves in, really. When you stay in equity, you're going in there, you're doing banking, and you're helping the judge settle his books.
It's just amazing how powerful it is. I have some background on the law side, and it's just it reminds me of the expression. It's not personal. It's just business. And then the other thing that comes to mind is it's a little goofy, but in Monty Python, the Holy Grail, with the Frenchman in the castle, kind of flipping off the guys down below. I mean, that's kind of, you're like in a defense. I mean, you're in if you do it right, obviously, and you have to know the method, but it just eliminates. It takes this mountain of stress, and then it just cuts it down, and it's just using the system that's there that we haven't been told about. I mean, this has always been there. This is the lifting of the veil. We just didn't have access to this knowledge, and now we do.
That's right. Yeah, equity makes you equal to the judge. So you just you send your message from your castle over to his castle, and he thanks you for it.
That's great. Thank you.
Daniel, did you have any questions?
I do not. Thank you.
Does anybody have any other questions? Raise your hand, please. Brent?
Actually, I have one, Michelle. Hey, to
Okay.
our speaker, I've been working while I've been listening. Did you learn from Will, if I might ask you?
No, I'm not sure
I'm
who
not
that
sure.
is.
Okay. Very familiar with some of the concepts. So thank you very much. I'm done.
Brent, you have a question? Brent Robert, you had your hand raised. I unmuted you. You have to unmute. There you are.
Hi, Julian. What will be the venue for the classes? Will it be Zoom conference calls, Telegram chats, etc.?
I'd do it on Zoom, most likely. Yeah, Zoom or Telegram.
When do you plan the class to start?
So as soon as we hit 10 students, we'll start the class, and or after say another 2 or 3 weeks, if we don't hit that, then I'll start anyway.
Swimmy, you have another question?
Thank you. Last question. What if we need help this week? And I wonder if you could throw in some examples of maybe questions that are not equitable to ask a judge.
Just private message me and we can work something out. Do one-on-one coaching.
Appreciate it. I yield. Thanks for a great presentation.
My pleasure.
So in the chat, Morgan wrote something. I'm going to read it. I'm led to believe that here is no crime if no victim, but there's bonds associated to each case, which are scrutinized or securitized and traded, CRIS fund, as well as retirement funds for the judges. I heard an affidavit of questionnaire is powerful, asking if anyone stands to benefit financially from the case, etc. Am I misguided?
No, you're right on, Morgan. Yeah, the court registry. I can't exactly remember what CRIS stands for. Court Registry Investment System, maybe. But you're right. It is tied to the judge's retirement funds, so they absolutely have a financial interest in the case, and that actually is one of the equitable questions that we ask. Your Honor, are you continuing this matter for your financial benefit or for the financial benefit of some third party?
Thank you. John, you have a question?
Did I push it? Yeah, I was just wondering. I didn't know I touched it. Like that was similar to the earlier example of Judge. Is this case number connected to a CUSIP number? Committee on Uniform Securities? Was it investment practices? Was it?
I think it's investment procedures or protocols, something like that. But yeah, it's a similar type of question. There's a number of verbal boots to the head that we use, and a lot of it's related to the fact that they are really doing a lot of things that they shouldn't be doing, turning cases into derivatives and trading them on the stock market all over the world, and all these things help compel the performance that we want to see happen.
Kansas?
How's everybody doing? I got a question kind of along the lines of that. So, I personally have a situation that I've just now recently found out about. I have a case that is 20 years old that is still open to today, which I feel like that has something to do with my kids. However, now looking at the birth certificates of my birth certificates, my first birth certificate and my second birth certificate, one of my birth certificates actually has a barcode on it, which to me, I would assume that would be the USPTO, which is trademarking. Is that not correct? or am I missing something here?
Well, the birth certificate is the property of the state. I mean, at the top of the birth certificate, it says the state of, such and such. So it is their property, and all of these things are financial instruments that are being turned into derivatives and traded on the stock market around the world. They all kind of represent performance contracts.
I actually into my Fidelity, and I can find my CUSIP. I did a little digging and figured that whole situation out. But in the process of doing that, going on Fidelity, I went back to Stock Market MBA and put the symbol number at the top and did it like a whole little search bar. Long story short, one of the funds that I have actually proves that this whole situation is slavery.
Wow. That's awesome. That's a great digging right there. I'd love to see that.
Yeah, I was actually surprised. And I've actually been able to get like the insurances from the bonds and like their contracts and stuff. It's been very interesting, I guess you can say, at the least.
Wow. That's pretty cool. Sounds like you should do your own class on how to do all that.
I don't know about doing all my own class. I can show y'all how to do it. It's not a problem at all. Dealing with what my case is, and I know Michelle's tired of hearing it. Everybody's honestly tired of hearing it, but I have to live it every day, and currently it's still going on. But it seems to be one thing after another that I have continuously found. Like, I have proof where the system is using somebody else's dead social security number through the CPS system, still drawing the funds off of that. So I've been kind of chasing the money aspect and trying to figure out the whole trafficking thing. What I have come to find out, though, is the Rothschilds actually have direct handling in with all this corruption. And the way that being is, okay, guess what? They're pretty much the bankers. We'll say the IMF, whatever. They have to use their money every day to do whatever it is. And the truth be fact, it's not even a money, it's a bill, it's an IOU. But yeah, anyways, sorry.
Candace, hang on a minute. Candace, I don't have a problem if you want to come on one night and just have a platform to go over everything with what you're dealing with and what you found. I don't have any problem with that at all. Just tell me when.
I wanted to kind of pick your brain, Michelle, truthfully, because one thing I have found out about my case, it's all null and void. It's void ab initio from the very beginning to the very end, all the way from my criminal side of the thing to the whole civil side of the thing. It is all void ab initio. The problem I'm having at this very moment being that there's a child, and we all know we all take children very sacred. It's the whole situation of, in my situation, they put a protection order against me on false allegations. And so I have this 5-year thing going on. I can't just go up and get my child, But that's what I kind of wanted to pick, your brain on, because I figured out that it took DHR literally 8 days before they contacted me to let me know that they had custody of my child. Therefore, I missed the shelter care hearing. I didn't have an attorney, and I couldn't even let the judge know what was going on. They carried on with this hearing without me being there or without anybody being there present for my family. That's total due process. That's lack of jurisdiction.
Well, if you want, I'll schedule a live for Thursday night, and we can all come on and have a big discussion, and maybe some of the gentlemen that are on the call now, who I know have knowledge, including Julian and Daniel and James. I don't know if Lex is still on. Lex is pretty brilliant too. If you want to do something like that, I'll schedule it Thursday night. We'll come on and you can talk.
Yeah, that would actually be fine with me. I kind of like when I'm helping other people, I kind of use my case not as a basis, but just kind of pinpoint, hey, look, maybe you should look here, whatever. I'm pretty sure I found a child trafficking ring, but nobody seems to be listening to what I'm saying over here. I don't know how to do it, but yeah. Like, because I was actually going to instead of going to the legislation, I was actually going to go through my community and start there. So I started looking at the committees. Well, there's something that's called Etowah County Children's Policy Committee. Well, when you go on the website and you look at, who all was on their board, my judge, he's actually the chairman. Then you have a DHR worker named Tiffany Smith. She's the vice chairman. You have Brittany Studdard. She was my social worker. She's the secretary of the same exact committee. Then you have another judge who was also my judge, also in this committee. You have 2 judges and 2 social workers. Something sounds kind of funny there, if you ask me.
Okay, so Candace, you see Daniel Joseph on here? Send him a private message.
Okay.
Yeah, I'd be really interested in joining this chat. It sounds like you got a lot of information that we could turn into equitable questions, especially for people that are dealing with CPS. So yeah, let me know when you do your talk.
Okay. You say Daniel Joseph?
Yes.
Okay. Yeah. Did you ever talk to Tom Heaney?
I talk to him all the time.
Yeah, he said he was going to reach out, talk to you. I don't know if he had talked to you yet or not. I told him, I said, me and you, we've talked. I told him that, you knew some of my case. You haven't learned my recent developments and things that I found out. It goes pretty deep, really.
All right. Well, we'll talk about it Thursday.
Right.
Put it on your schedule, and let's see. I'm trying to find who had their hand raised. I don't see her anymore. But yeah, reach out to Daniel Joseph, and Thursday night, guys, we'll go on and we'll let Candace talk and show what information she has and everything. So JT, you have another question?
Yes, I was just looking online. You can't find a lot of things what you're talking about unless you go under equitable law. But it said that the annulment part is like the marriage never existed. Is that in the other part of the law? That's what they use that word, right? So in equitable law, you don't use that, you lose rescission, right?
That's right, and annulment is more of a commercial term, and it's really strict. I mean, you're probably not going to be able to get an annulment unless it's like a really specific situation, like the person wasn't legally able to get married in the first place because they were already married or something. But also, you can't really find this stuff online. But where you can find it is in Black's Law Dictionary and Burton's Legal Thesaurus and basically the law books that the judges use, Levine's Manual on Commercial Law and other stuff like that. If you look up rescission in there, it'll tell you about the equity, and I can show you how to put it together.
Really, I'm not wanting to do all that. I just want to have the template. So if I pay for the template for you to just give it to me, I'll pay for the template and then I'll take it to I'll take it to wherever I got to go to. Okay.
Yeah, I mean, I can teach you how to make the notice of rescission, but you got to know what the stuff in there means. I mean, if you're ever challenged on it, you're gonna have to know how to stand on it. It's not super complicated. I mean, I can teach you pretty easy.
Yeah.
It's not gonna take that long.
Well, I'll take notes that day when we're doing it, but I don't want to wait too long, but I do want to do it before November. You know what I'm saying?
Yeah, you got plenty of time.
Yeah. Okay. Well, I will text you later on, and I know we're still talking about everything, but I appreciate it.
Sure.
Dave, you have a question?
A question.
Dave-O had his hand raised. You have to unmute. Okay, Candace.
Okay. So considering that when we look at our birth certificates, social security numbers, and things like that, considering the fact that it's contract, wouldn't it be the fact of them not giving us full disclosure on everything when we sign those documents? Wouldn't that be a trespass?
Well, it was actually Mom who signed us over to the state, you know, and I mean, we might have been too young to agree at the time, but what was that?
Even like when we have our own children, because at that time we pretty much go through the same footsteps that they go through at that time. So, I mean,
Yeah, you volunteer. I mean, if you have the child in a hospital and you sign the paperwork they give you, and I mean, you know, they didn't give you full disclosure, I guess, but I mean, it's a gray area to them. I mean, they work within that gray area. Like to them, oh, you could have looked this up or blah 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 blah. I mean, obviously, it's not moral what they're doing. That's not what I'm saying. But
right.
in a certain sense,
I thought when you have a contract, though, that you have two people that when you're in a contract, you understand you have almost like, as you can say, a disclosure of the contract.
yeah. I mean, I don't know how exactly they get around that, but they do that all the time. I mean, there's all sorts of contracts that we agree to that we kind of regret later, but. I mean, equity teaches you how to deal with that. I mean, also even your silence can be consent to a contract or assent rather. Just not saying anything, they'll tell you that you agreed to it. So, I mean, is it moral? No. I mean, the system's broken, but you know, they also gave us a remedy. So that's the power of equity right there.
So, something I did come across within looking through Fidelity and just like looking at certain numbers that are attached to us, they're, governmental businesses or whatnot. EIN numbers, they actually have a bond. I didn't know that, but I just got curious. I was counting up the numbers and stuff. I was like, you know what? I'm fixing to run these just to see what pops up on those. Your EIN numbers, they have bonds. Your Treasury Direct accounts, they have a bond on them.
Wow. Yeah, that's crazy. I certainly wouldn't be volunteering for one of those anytime soon. That's good to know.
Yeah. No, I have actually have an irrevocable EIN number, and I have a direct Treasury account. And I was just, what it was is me and my partner, we was just sitting here thinking, we was like, we wonder if this is just random numbers that they, pick, because you can only put so many numbers through so many times. So we was like, okay, just let's pick out some random numbers. We ran that, nothing pops up. So I can say this much: I've correlated the DTCC GMEI with the Fidelity, ran it through Stock Market MBA, and ran the LEIs. They all connect. Every bit of them connect.
This is very interesting. Yeah, I'd like to learn more when you kind of put this all together for your talk.
Well, see, what started it is because of the whole W4 situation, and how everybody was talking about GME, was it GMEI utility, and then Fidelity came about, and I just, one thing led to another. I didn't like read deep with them because there's so much in it, but like just certain words just kind of caught my attention. So I was like, I wonder if this is going to correlate. So that's how Stock Market MBA come up. Like, I can't even remember how I even come about that. Like, it wasn't nobody told me, hey, look, why don't you do this? It was something that I read off of Fidelity, and yeah. It's interesting. It's quite interesting, that's for sure.
Thursday, Candace, Thursday.
What time?
You tell me.
Oh, I'm gonna tell you right now, I'm a late person. I'm not a morning person at all. That's why I'm always up. That's why you always get a message from me in the middle of the night.
Okay, so you want it 9 o'clock Eastern time Thursday. How's that?
That'll work.
Okay. You yield?
Yes, ma'am. Thank you.
You're welcome. Anybody have any other questions? Please raise your hand. Dave-O, you're still unmuted. You had your hand raised. Did you want to talk? Okay, so I guess it's kind of a wrap, Julian. You have any last words you want to say? And if I can make a suggestion, why don't you create like a little post with your contact and the, class starting so and so, to contact you, and then put it into the chat.
We'll absolutely do that. And I just want to say thank you, Michelle, for giving me the time to speak to your members. And thank you, everybody, for listening in. And just look forward to answering all your messages and moving forward with all this.
And before we end, last call. Anybody have any questions? Please raise your hand. John?
Just quickly before you go on, thanks everybody. In equity, the rescission has to go with the repudiation. Is that what we were saying in the review, or the other way around?
Yeah, rescission necessitates repudiation, meaning that the rescission makes it as if it never existed, and you need to act as if it never existed. And I can teach you how to do that.
All right, everybody. I'm going to leave the chat open for an open chat, so I will unmute everybody. Julian, thank you so much. Truly a pleasure. And put your info in the chat when you plan on starting the class so people can reach out to you. And thanks. I'm going to stop the recording now. And I will open up the open chat, so just give me 1 minute.
All right. Thanks, everybody. Y'all have a good night.